Good morning, Judge. I'm approaching on Jaime Estrada.
Okay.
He's here for a termination of PPI. Completed SOT. He said he's paid all the fees, but we're still waiting for receiver certificates.
Are you ready? Did you receive word that he's paid everything as well?
Yeah. So the only thing about that, I emailed it to Brenda. We are waiting on progress report from the CS. So as for an update, I've not received anything.
Okay, so do you have anywhere else to go?
I do have to run to ERD. What time does docket usually end?
About 12:30ish.
Okay.
You know, I mean, today's a light day, so maybe 12. I don't know. We haven't gotten word. I guess we could roll it to tomorrow to see.
So here's the setup. The defendant says he paid his fees, but no one has proof yet. It's like showing up to class without your homework and claiming your dog ate your email. Who do you believe, the system or the slip?
Yeah, I was just gonna say that if we if I come back and we're still waiting, if we roll it, can we waive him just because he's here today? And
Does he have a receipt that he's paid?
I
Have you asked him? Yeah. See if he because they're gonna give him a receipt anytime you pay. You know, he should have a receipt.
Let me follow up.
Yeah, see that, and then so that we know that he actually did pay, and then assuming that he did, then yeah, we'll waive tomorrow.
Okay. Judge, can we deal with the
Oh. Come up, Mr. Lestrade.
Three open cases, 3 bonds. That's not just bad luck, that's a legal pattern. Judges take that seriously. Think about it. If someone skips court 3 times, what would you do in the judge's seat?
Let's do this. I'm not going to do anything until this lawyer gets here. All I know is he's got 3 open cases. They're all at 7503 because you continually take off. You come to court when you want to come to court. You don't come to court.
People say don't come to court, you talking about the probation.
Let's wait for your lawyer to get here and we'll see. But all I know is you've got 3 open cases. All the bonds are 7503, which indicates to me that you've taken off 3 different times. So let's see. So just take a seat for me. I mean, I'm not going to argue with you. I'm going to wait for your lawyer to get here, and then we'll go from there.
Okay, real talk, this isn't just a scheduling issue. Missing court dates means judges lose trust fast. And trust is everything when you're asking for bond, leniency, or second chances. What do you think, should repeat no-shows get another shot, or are they playing the system?
You're supposed to come to court when the reset says, not when you want to come to court.
No, he told me not to come to court, Judge. He said not.
You can't come to court, right? But you're supposed to come to court when the reset says. And we have multiple instances of you not doing that. I mean, I don't know how else to say it. So let's wait for your lawyer to get here and we'll go from there. Just take a seat.
Judge, I already emailed him because he got one.
He got another new one, so hopefully he'll, and he's usually pretty good about showing up. So. Right. Ready? How are you? You know. Who do you want to talk about first?
Let's do Lestrade.
Okay. Come up, Mr. Lestrade.
Just,
Beer and a bag of candy sounds like a convenience store craving. Right, except it's theft case number 3. Viewers, at what point does this stop being petty and start becoming a real problem?
So Judge, there was misunderstanding on this case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him, get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the judge revoked his bond based on those old cases. He said he received the letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your end in this case, because I don't know anything about it. Mr. Lestrap, you've now picked up a 3rd theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Boom! The judge just called it out. He told this guy not to go back to that Walgreens, and now, same store again. It's like yelling into the void. How many warnings are too many before trust is gone for good?
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
Just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment. Has some assistance from his mom, but obviously that's not a whole lot. That's the number.
Is that mom over there?
I'm not sure.
No, it's not. She at home.
Here's where it gets messy. The defendant says he's injured and homeless, and the court does offer resources. But after repeat violations, can sympathy override public safety? What's your take? Drop it in the comments.
Did you come with mom today?
Yes, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to. Over a damn case of beer and a large...
Now here's where it gets complicated. A defendant breaks his leg while fleeing and now claims he's too injured to show up. But is it legit or just another dodge? The court's skeptical, and frankly, so are we. Ever seen a case like this go sideways? Share it in the comments.
large pack of candy. Mr. Lestrap, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR bomb. You know, perhaps, I don't know. But you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today. It goes with you. I'm with you, though.
Appreciate it.
We're saying the bond's ultimate.
I will. Good morning, gentlemen. You are Mr. Lowry. You must be Mr. Benson. All right, gentlemen, both of you have picked up criminal cases, and it looks like you've worked out an agreement with the state and your defense lawyer.
Important legal moment here. The judge warns that even small thefts stack up that third strike. It could turn a candy bar into a felony. Wild. Write one more slip, and it's not just jail, it's years.
It looks like both of you, Mr. Benson, are charged with theft, and you're facing up to 6 months in jail and/or a $2,000 fine. And Mr. Lowry, you were charged with criminal trespass as well. You're facing up to 6 months in jail and/or a $2,000 fine. The agreement you have worked out, Mr. Benson, is 22 days in jail, credit for the 22 days so that you are done today. You need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point they're going to hit you with a felony, and instead of days, you will be looking at years. From now on, you are now facing a minimum of 30 days in jail. Do you understand? Mr. Lowry, you are with your criminal trespass, they've offered you 122 days in jail with credit for the 122 days that you've done. So likewise, you're also done with us today as well. It will go on your record. You can never take it off. And from now on, you're facing a minimum of 30 days in jail. Do you understand? Is this what both of you want to do?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, there's no turning back. It will go on your record. It'll stay there forever. How do you plead to the offense, Mr. Benson? I'm going to find you guilty. I will follow the agreement, send you to it. Mr. Lowry? How do you plead to the offense? Guilty or not guilty? All right. I'm going to find you guilty as well. I'm going to, if any enhancements, just abandon it. Do we need to do it on the theft?
The second conviction.
Got it. All right. So, Mr. Benson, you have a prior theft from 2019. Is this true?
Yes, sir.
Okay. This now makes two. A third, you're looking at a felony charge. No matter if it's a pack of gum, a big pack of candy, be careful. You could be facing some serious time next time. You understand? Okay, so true to the first. We'll abandon the other one. All right, good luck, gentlemen. Thanks.
All right, gentlemen. Go ahead.
Oh, and Mr. Benson, your second case will be dismissed. I didn't realize you had it. Oh,
Yeah. I was told I needed to approach on Mr. McCullum. He's not here today.
we have quite the. Did you represent him before?
No.
Okay, we have quite the history with this gentleman,
Okay.
where he's had a couple cases in here with numerous bond violations. He pled not too long ago, or no, I think did it get dismissed or did he plead? I don't know.
One of them pled and the other one got dismissed.